Before we begin, a quick and important disclaimer. This documentary is for educational and entertainment purposes only and does not constitute legal, financial, or psychological advice. Divorce laws vary significantly by state and jurisdiction, and the specific facts of your situation may lead to different outcomes. The information presented here is not a substitute for the counsel of a licensed attorney, a certified mediator, or a qualified financial professional. Please conduct your own due diligence and consult with a professional in your area before making any decisions regarding your legal rights or personal finances. Every year in the United States, roughly 600,000 marriages end. For decades, the script for those endings was written in a courtroom. It was a zero-sum game of winners and losers, a high-stakes litigation machine that burned through $30,000 to $100,000 in legal fees per couple and left families emotionally bankrupt. But right now, a quiet revolution is dismantling the traditional American divorce. There is a philosophy emerging that treats the end of a marriage not as a legal war to be won, but as a complex reorganization to be managed. It is called mediation, and it is the most significant shift in domestic law since the introduction of no-fault divorce in the 1970s. While most people believe a judge needs to decide who gets the house or who keeps the kids on Tuesdays, the data shows that 90% of cases are actually settled out of court. The question isn't whether you will settle. The question is whether you will do it after 2 years of traumatic litigation, or through a structured, philosophical approach that preserves your wealth and your sanity. Today, we are peeling back the curtain on the multi-billion-dollar divorce industrial complex to show you the alternative path that the legal system often doesn't want you to see. This is a masterclass in the philosophy of mediation. By the end of this deep dive, you will understand how to bypass the adversarial trap, how the shadow of the law dictates your negotiation power, and how to apply high-level conflict resolution tactics that are currently being used by the top 1% to keep their private lives out of the public record. Whether you are navigating a separation right now or simply want to understand the changing fabric of the American family unit, this exploration will provide the blueprint for a civilized exit. To understand why mediation is exploding in popularity across states like California, New York, and Florida, we first have to look at the historical failure of the adversarial system. For over a century, the U.S. legal system treated divorce like a car accident or a breach of contract. It forced two people who once loved each other into the roles of plaintiff and defendant. In this structure, the goal is zealous advocacy, which is a legal term for fighting as hard as possible to get the biggest piece of the pie. But when you apply that logic to a family with children and shared retirement accounts, the collateral damage is catastrophic. Case studies from the American Bar Association suggest that the average litigated divorce in the U.S. takes between 12 and 18 months. During that time, the status quo is often frozen. Assets are locked, communication is channeled through expensive intermediaries, and the emotional toll on children becomes a secondary concern to the discovery process. Mediation, by contrast, is rooted in the philosophy of self-determination. This is the radical idea that you and your spouse are the world's leading experts on your own lives, not a judge who has 15 minutes to look at your file between a dozen other cases. Let's look at the financial philosophy behind this. In a traditional litigated setting, you pay two separate attorneys. If each attorney charges an average of $350 per hour, a conservative estimate in many U.S. metros, and both are present for every phone call, every email, and every court appearance, the costs scale exponentially. Mediation introduces a neutral third party. Instead of paying two people to fight, you pay one person to facilitate. This isn't just about saving money, it's about value creation. In negotiation theory, we distinguish between distributive bargaining, slicing a fixed pie, and integrative bargaining, expanding the pie. Mediation uses the latter. For example, instead of a judge ordering the sale of a family home during a high-interest rate market, a mediator helps the couple find a bird nesting arrangement or an equity buyout that protects the long-term investment for both parties. The philosophical core of American mediation is built on 3 pillars: neutrality, confidentiality, and voluntary participation. First, let's talk about neutrality. In the U.S. court system, the judge is a neutral arbiter, but they are also a figure of authority who imposes a decision. A mediator has no power to impose a decision. This shifts the psychology of the room. When you realize the mediator can't rule against you, the defensive walls start to come down. You move from a position of how do I protect myself from a bad ruling to how do I solve this problem so I can move on with my life. Second is confidentiality. In the United States, court records are generally public. Your financial disclosures, your allegations of misconduct, and the intimate details of your family's struggles can be accessed by anyone with a Pacer account or a trip to the county clerk. Mediation happens behind closed doors. Under the Uniform Mediation Act, which has been adopted by many states, what is said in mediation stays in mediation. It cannot be used as evidence if the case eventually goes to trial. This safe space philosophy allows for option generation, without the fear of appearing weak or conceding a legal point. Third is voluntary participation. You can be ordered to attend mediation by a judge, a common practice in states like Florida and North Carolina, but you cannot be forced to reach an agreement. This maintains the balance of power. It ensures that any memorandum of understanding produced at the end is a reflection of mutual consent rather than judicial coercion. But we have to be realistic about the historical trends. Mediation isn't a magic wand. It is a rigorous, often grueling process of interest-based negotiation. To succeed, you have to move past positions and get to interests. A position is, I want the house. An interest is, I want my children to stay in their current school district, and I need a sense of housing security. When you identify the interest, you realize there are 5 different ways to solve the problem that don't necessarily involve keeping that specific house. As we move forward in this documentary, we are going to break down the 6 stages of the mediation process used by the top firms in the country. We will look at how the caucus method, where the mediator moves between separate rooms, can break a deadlock that would take 6 months to resolve in a courtroom. We will examine the financial neutral role, where a single CPA works for both sides to minimize the tax burden of the split, potentially saving the family tens of thousands of dollars in capital gains taxes. The American family is evolving. The gray divorce phenomenon, couples over 50 splitting after decades, has created a new demand for sophisticated mediation that focuses on pension division and healthcare. Meanwhile, younger generations are utilizing prenuptial mediation to set the groundwork for their marriage before it even starts. We are witnessing a fundamental shift in the American consciousness. The realization that while the marriage may be over, the family still exists, and the way you end a chapter determines the quality of the next one. This isn't just about legal paperwork. It is about the philosophy of the good divorce. And it starts with understanding the power of the table over the power of the bench. Over the next 9 parts of this series, we are going to give you the exact tools, the psychological frameworks, and the legal insights you need to master this process. From the initial consultation to the final judgment of dissolution, this is the definitive guide to the philosophy of divorce mediation in America. To truly grasp the shift from the courtroom to the conference table, we must examine the specific mechanics of the initial consultation, which serves as the philosophical foundation for the entire process. Imagine a couple in 2026, let's call them Sarah and Michael, living in a suburb of Austin, Texas. They have 2 children, a primary residence with significant equity, and a mix of retirement accounts and student loan debt. In a traditional litigation model, Sarah would meet with an attorney who would identify her as the petitioner. That attorney's job, by design, is to view Michael as an adversary. The very first document filed would be a formal petition, served perhaps at Michael's office, instantly triggering a fight-or-flight response. The philosophy here is aggressive boundary setting. In mediation, the start is fundamentally different. Sarah and Michael enter a room together, or join a secure digital link, to meet with a neutral mediator. The philosophy of this first hour is orientation and assessment. The mediator isn't looking for who is at fault for the breakdown of the marriage. They are looking for the common denominators of their future. The mediator explains that while the law provides a framework, it is a blunt instrument. For instance, Texas is a community property state, but a judge's idea of a just and right division might not account for the tax implications of Sarah taking the house while Michael takes the 401k. The mediator's role in this first stage is to move the couple from a state of emotional reactivity to one of logical cooperation. Historical trends in U.S. family law show that the more control a couple feels they have over the process, the more likely they are to follow the resulting agreement. This is the concept of psychological buy-in. When a judge hands down an order, one party often feels victimized, which leads to post-decree litigation, returning to court years later because someone isn't following the visitation schedule. In Sarah and Michael's case, the mediator begins by establishing ground rules. These aren't just polite suggestions. They are a structural framework designed to prevent the hijacking of the process by past grievances. These rules often include a moratorium on making major financial changes, a commitment to full transparency, and an agreement to keep the children out of the middle of the negotiations. Step 1 of this deep dive is the comprehensive information gathering phase. This is where the philosophy of transparency meets the reality of American finance. In 2026, assets are more complex than ever. We aren't just talking about bank accounts and cars. We are talking about RSUs, stock options, digital assets, and complex insurance products. In a litigated divorce, you use a process called discovery. This involves formal requests for production, subpoenas, and depositions. It is slow, expensive, and intentionally intrusive. One party might hide a credit card statement just to be difficult, leading to a motion to compel and a court hearing that costs $5,000 in legal fees to find $500 worth of data. Mediation replaces discovery with voluntary disclosure. The philosophy is simple: we cannot solve a problem we cannot see. The mediator provides Sarah and Michael with a roadmap of every document needed: tax returns from the last 3 years, current mortgage statements, appraisals of the home, and detailed breakdowns of debt. By gathering this information voluntarily, the couple saves thousands in administrative legal costs. They are effectively acting as their own paralegals, guided by the mediator's checklist. This phase often uncovers the first major hurdle: the emotional value of assets. Michael might be deeply attached to his retirement fund because he worked 60-hour weeks for 20 years to build it. Sarah might be attached to the house because it represents the only stability her children have known. A judge doesn't care about these attachments. A judge sees numbers on a ledger. A mediator, however, uses these emotional attachments as leverage points for creative problem-solving. This leads us to the second pillar of the masterclass: the transition from positions to interests. In the Austin case study, Sarah's position might be, "I want 70% of the house equity." Michael's position might be, "That's unfair, I want a 50-50 split of everything." If they stay in these positions, they reach an impasse. The mediator's job is to dig deeper. Why does Sarah want 70%? Through guided questioning, it's revealed that she is terrified she won't be able to afford a new place in their specific school district on her current salary. Why does Michael want 50%? Because he feels his contributions to the family's wealth are being erased. The interest-based philosophy allows them to look at the problem differently. They might agree that Michael takes a larger share of the liquid assets now in exchange for Sarah staying in the home for 3 more years until the youngest child finishes middle school, at which point the house will be sold and the proceeds split. This is a nuanced, multi-year financial plan that a court rarely has the time or the inclination to draft. It's a solution that addresses Sarah's fear of instability and Michael's need for fairness. This is the hallmark of high-level mediation, creating a bespoke garment rather than an off-the-rack suit. Data from the American Academy of Matrimonial Lawyers suggests that the average duration of a mediated divorce is between 3 and 6 months, compared to over a year for litigation. The reason for this speed isn't that mediation skips steps. It's that it removes the friction of the adversarial machine. In 2026, time is the most valuable asset any family has. Every month spent in legal limbo is a month of high stress, stalled financial planning, and emotional stagnation. By compressing the timeline, mediation minimizes the window of conflict. However, we must address the power imbalance. A common critique of mediation philosophy is, what if one person is more assertive or more financially literate than the other? In the US, professional mediators are trained specifically in power balancing. If Michael has always handled the finances and Sarah has been a stay-at-home parent, the mediator doesn't just let Michael dictate the terms. They may bring in a certified divorce financial analyst or CDFA. This neutral professional builds a neutral financial reality that both parties can understand. They create 5-year and 10-year projections showing what Sarah's life looks like and what Michael's life looks like under different scenarios. This data-driven approach removes the he said, she said, and replaces it with the math says. By the end of this second phase, Sarah and Michael have moved from the initial shock of separation to a working partnership. They have a shared folder of financial truths and a set of identified interests. They have avoided the public filing of embarrassing allegations and kept their legal fees in the hundreds or low thousands instead of the tens of thousands. They are standing at the threshold of the most difficult part of the process: the actual negotiation of the parenting plan and the final division of the marital estate. But as they prepare for the next session, a new complication arises. Michael's attorney, who he kept on retainer just in case, is whispering in his ear that he's giving up too much. This brings us to the dangerous intersection of mediation and outside legal influence. How do you stay committed to a peaceful philosophy when the world around you is telling you to go to war? In the next part, we will explore the precise tactics used to handle high-conflict personalities and what happens when the mediation process hits a brick wall. We will break down the caucusing technique, the secret weapon of the world's best mediators, and how it can turn a total breakdown of communication into a signed agreement in a matter of hours. The stakes are about to get much higher. The transition from a joint session to a caucus is often the most pivotal moment in a high-stakes American divorce. In the world of 2026, where digital transparency and rapid-fire communication have heightened the emotional stakes of every conflict, the caucus acts as a psychological pressure valve. Imagine Michael sitting in a glass-walled conference room in downtown Austin. His phone is buzzing with messages from his litigation-focused attorney, who is warning him that the current settlement path might result in historical trends where the higher-earning spouse loses significant leverage. Michael is starting to retract. He is becoming defensive, his body language is closing off, and the cooperative spirit of the earlier hours is evaporating. This is the moment a master mediator recognizes the breakdown. They call for a caucus, a private meeting where the mediator speaks with each party individually. The philosophy of the caucus is built on the concept of the safe harbor. In a joint session, Sarah and Michael are performing for each other. They are protecting their egos and their perceived legal positions. When Michael is alone with the mediator, the performance stops. The mediator can now employ a technique known as reality testing. Instead of arguing with Michael, the mediator asks a series of calibrated questions about potential outcomes. If Michael insists on a 50-50 split of the house equity immediately, the mediator might ask, if this goes to a trial 6 months from now, and the judge orders the house sold during a market dip, what is the net financial impact after you factor in an additional $20,000 in trial prep fees? This isn't the mediator taking a side. It is the mediator holding up a mirror to the risks of the adversarial path. Step by step, the caucus allows the mediator to discover what we call the bottom line versus the BATNA, the best alternative to a negotiated agreement. In this 2026 case study, Michael's BATNA is going to court. The mediator helps him realize that his BATNA is actually quite weak when you consider the loss of privacy and the impact on his relationship with his children. While this is happening in room A, Sarah is in room B. She is frustrated. She feels Michael is being unreasonable. The mediator enters her room and performs the same process but from her perspective. The mediator validates her emotions without agreeing with her legal stance. This distinction is vital. By listening to Sarah's fears about her future mortgage eligibility in a 2026 economy with fluctuating interest rates, the mediator helps her move from anger to a solution-oriented mindset. One of the most powerful tools used during these private sessions is the bracketed proposal. When parties are miles apart on a number, say a monthly alimony or spousal support figure, a mediator might suggest a bracket. They might ask Michael, would you be willing to offer between $3,000 and $3,500 if Sarah agrees to waive her interest in your startup stock options? This creates a range of possibilities that feels less like an ultimatum and more like a mathematical exercise. Historical trends in U.S. mediation show that once a couple enters a bracket, the psychological distance to a final number shrinks by nearly 70%. Let's look at a secondary case study involving a high-conflict personality, which is a frequent challenge in the American legal landscape. Imagine a couple, James and Linda, who have a history of high-intensity arguments. In a traditional courtroom, these two would be silenced by their attorneys, but their resentment would bleed into their co-parenting for the next decade. In a 2026 mediation setting, the mediator uses the parallel track philosophy. They handle the financial division in one track and the emotional parenting plan in another. When James becomes volatile in a caucus, the mediator uses a technique called de-escalation through factual grounding. They pivot James away from what Linda did in 2023 and toward the specific calendar for the 2026 winter holidays. By forcing the brain to engage with logistical data, the mediator physically lowers the parties' cortisol levels. This leads us to the crucial role of the parenting plan. In the United States, the philosophy of custody has shifted from the old-school primary versus secondary custody to the modern concept of shared parenting time and decision-making responsibility. The mediation of a parenting plan in 2026 is a masterclass in detail. It isn't enough to say every other weekend. A mediated plan accounts for the nuances of modern life. Who handles the logistics of extracurricular activities? How are virtual visits managed if one parent travels for work? And what is the specific protocol for introducing a new romantic partner to the children? By diving deep into these details, Mediation prevents the ambiguity that leads back to the courtroom. Consider the right of first refusal clause. In a litigated order, this might be a single sentence. In a mediated agreement, James and Linda might spend 2 hours defining exactly when it triggers. Perhaps if one parent is unavailable for more than 4 hours, and how the communication must happen, such as through a dedicated co-parenting app like Our Family Wizard. This level of granularity is where the true value of mediation lies. It is an insurance policy against future conflict. The data suggests that children and families who use mediation tend to have better long-term psychological outcomes because they are not witnesses to a protracted legal war. They see their parents, even if they are living in separate homes, functioning as a logistical team. This is the co-parenting business model philosophy. You are no longer romantic partners, but you are business partners in the enterprise of raising a human being. As the mediation sessions progress, the physical result is the Memorandum of Understanding, or MOU. This is a non-binding document that outlines every single point of agreement reached during the caucuses and joint sessions. It covers the division of the 401k, the refinancing of the family home, the allocation of the 529 college savings accounts, and the minutiae of the summer vacation schedule. For Sarah and Michael in Austin, the MOU represents the first time in 2 years they have seen a clear path to their future. But the MOU is not the end of the journey. There is a final, dangerous hurdle that many couples fail to anticipate: the review period. This is where the philosophy of mediation meets the cold reality of the legal system. Once the MOU is drafted, each party takes it to their respective review attorneys. This is the moment of truth. A review attorney's job is to look for holes in the agreement. If Sarah's attorney tells her she could have gotten 10% more in a courtroom, the entire mediation can collapse in an instant. This creates a fascinating tension between the collaborative philosophy of the mediator and the protective philosophy of the independent counsel. How do Sarah and Michael protect their hard-won agreement from being torn apart by the very lawyers hired to protect them? And what happens when a hidden asset, a forgotten cryptocurrency wallet or a secret bank account, suddenly comes to light just as they are about to sign? We are about to look at the dark side of the process. In the next part, we will explore the asset tracing protocols used in 2026 mediation and the psychological warfare that occurs when the finish line is in sight. We will reveal how the most successful mediators handle the buyer's remorse that hits nearly every person the night before they sign their life away. The most intense part of the deep dive is just beginning. The psychological phenomenon of the 11th hour collapse is a well-documented reality in the American mediation landscape. As we move into the fourth stage of our masterclass, we must address the moment of crisis where the philosophy of cooperation meets the primal fear of survival. For Sarah and Michael in Austin, the Memorandum of Understanding is sitting on their respective kitchen tables. The year is 2026, and the economic climate is defined by high volatility. Suddenly, the math that seemed fair in the mediator's office at 2 p.m. looks like a death sentence at 2 a.m. This is where buyer's remorse sets in. Michael looks at the alimony figure and calculates that he will be living in a one-bedroom apartment, while his former spouse stays in their 4-bedroom home. Sarah looks at the retirement split and realizes she will have to work 5 years longer than she originally planned. In this high-stakes environment, the philosophy of mediation shifts from creation to preservation of the agreement. A master mediator anticipates this. They know that the human brain, when under extreme stress, defaults to a scarcity mindset. To combat this, mediators use a technique called future pacing. They don't just look at what is being given up today. They force the parties to visualize their lives 3 years from now if they do not sign. Imagine if Michael rejects this deal. He moves into a litigated track. He immediately owes a $15,000 retainer. He enters the discovery phase where every text message he sent in the last 5 years is scrutinized. He faces a trial date in 2027. By the time a judge makes a ruling, the legal fees have eaten the very equity he was trying to protect. Future pacing is the cold water that shocks the parties back into the reality of their best alternative to a negotiated agreement. But what happens when the reason for the remorse isn't psychological but factual? In the 2026 landscape, the emergence of digital assets has complicated the disclosure phase. Let's look at a case study involving a character named David, a software engineer in San Jose. During the final review of his mediated agreement, his spouse, Elena, discovers through a casual social media post that David had been involved in an early-stage AI startup that recently went through a seed round. In a traditional litigated setting, this would lead to a flurry of subpoenas and a potential fraud claim. In the philosophy of mediation, this is handled through the remedial disclosure protocol. The mediator does not judge David. Instead, they explain the legal concept of the fiduciary duty to disclose. In most U.S. jurisdictions, spouses have a duty of the highest good faith and fair dealing toward each other until the final judgment is signed. If David hides this asset and it is discovered later, the court has the power to award 100% of that asset to Elena as a penalty. By presenting the historical trends of judicial sanctions, the mediator convinces David that the only logical path is to bring the asset to the table. They then apply the philosophy of valuation at a specific point in time. Since the startup's value is speculative, they might negotiate a retained interest or a Lynchburg clause, where Elena receives a percentage of the future liquidity event in exchange for taking a smaller portion of the current liquid cash. This is a sophisticated financial move that keeps the mediation on track while ensuring fairness. Step by step, the mediation must now survive the review attorney phase. In the United States, it is a best practice for each party to have their own independent counsel review the final agreement before it is signed. This is a dangerous moment. A review attorney who was not in the room during the 12 hours of negotiation does not see the trade-offs. They only see a document where their client appears to be conceding. If Michael's lawyer says, "I can get you a better deal on the house," he is often ignoring the fact that Michael traded that house equity for a waiver of his pension. To manage this, the philosophy of mediation incorporates the collaborative review. Instead of Sarah and Michael's lawyers sending aggressive letters back and forth, the mediator facilitates a four-way meeting. The lawyers are brought into the collaborative bubble. The mediator explains the global settlement logic, how every piece of the agreement is a Jenga block supporting the others. Pull one out and the whole structure collapses. This is where the mediator's skill in attorney management becomes as important as their skill in client management. They must remind the lawyers that their clients have chosen a path of self-determination, and that undoing the deal now would be a violation of the client's stated interests. Now let's go deeper into the specific data of asset tracing in 2026. In America, we are seeing a massive transfer of wealth from the baby boomer generation to their divorcing Gen X and millennial children. This brings up the philosophy of separate versus community property. If Michael's parents gave him $50,000 for the down payment on the Austin house in 2018, is that a gift to him or a gift to the marriage? The mediator uses a technique called tracing the source of funds. They look at the intent at the time of the gift. They look at whether the funds were commingled in a joint account. In a courtroom, this would be a battle of expert witnesses costing $300 an hour each. In mediation, the couple might agree to a pro rata buyback, where Michael gets his initial $50,000 back off the top of the sale proceeds, and the remaining appreciation is split 50-50. This is a pragmatic middle ground that respects the history of the money, while acknowledging the reality of the marriage. As the documents are finalized, we reach the stage of formalizing the agreement. This involves the creation of a stipulated judgment. In the US, this is the legal document that a judge actually signs to end the marriage. But there is a secret to this process that most people don't know. Even after the mediator finishes their work, the clock of the American legal system is still ticking. In states like California, there is a mandatory 6-month waiting period from the date of service before you can be officially single. In other states, it's 30 or 60 days. The philosophy of mediation during this cooling-off period is one of disciplined silence. The mediator often advises the couple to begin living their new financial lives as if the judgment is already signed, testing the vibe of the agreement before it becomes an irrevocable court order. We have now covered the hook, the orientation, the negotiation, and the crisis of the final review. But we haven't touched the most controversial and difficult part of the entire philosophy: the child support and alimony formula. In 2026, the traditional models of the husband pays the wife are being dismantled as income parity becomes more common. However, the emotional weight of writing a check to an ex remains the #1 deal killer in American mediation. How do you convince someone to pay thousands of dollars a month to a person they no longer like? How does the philosophy of income shares work when one parent decides to stop working just to avoid paying support? And what happens when the mediator discovers that one party is using the children as a bargaining chip for more money? We are about to enter the darkest corridors of the human ego. In the next part, we will break down the power play tactics used in support negotiations and show you the exact mathematical models that mediators use to neutralize greed. We will also explore the virtual divorce trend that is allowing couples to settle their lives without ever seeing each other's faces. The real battle for the future starts now. The philosophy of financial support in America has undergone a radical transformation by the year 2026. Historically, spousal support or alimony was viewed through the lens of a lifelong obligation. In the modern era, the philosophy has shifted toward a rehabilitative model. The core objective is no longer to provide a permanent link between two former partners, but to provide a bridge that allows the lower-earning spouse to achieve a standard of living that is as close as possible to the marital status quo, while they transition to self-sufficiency. This is where the mediation table becomes a laboratory for complex socioeconomic engineering. Consider the case of Robert and Jennifer. Robert is a high-level executive at a renewable energy firm in Denver, earning a significant six-figure salary. Jennifer has spent the last 12 years managing the household and supporting Robert's career, resulting in a significant gap in her professional resume. In a traditional courtroom, a judge might apply a rigid state formula that dictates Robert pays Jennifer a specific dollar amount for a specific number of years based strictly on the length of the marriage. This is the distributive justice model. It is cold, mathematical, and often leaves both parties feeling resentful. Robert feels like he is being taxed for his success, and Jennifer feels like the amount is insufficient to cover the rising costs of housing and healthcare in 2026. In mediation, we apply the interest-based financial philosophy. The mediator moves the conversation away from the number and toward the goal. Jennifer's goal isn't just a monthly check. It is the ability to re-enter the workforce as a digital marketing specialist. Robert's goal is to have a predictable end date for his financial obligation, so he can plan for his own retirement. The mediator facilitates a step-by-step plan. Perhaps Robert pays a higher amount for the first 2 years while Jennifer completes a specialized certification program, followed by a gradual step-down in payments over the subsequent 3 years. This is called a step-down alimony provision. It incentivizes Jennifer's professional growth while providing Robert with the light at the end of the tunnel he requires. However, we must address the most significant friction point in American family law: the intersection of child support and spousal maintenance. In many U.S. states, these two figures are calculated independently, but in reality, they come from the same pocket. By 2026, many mediators are using the global cash flow analysis. This involves looking at the net disposable income of both households after all taxes and mandatory expenses are paid. The goal is to ensure that the children don't experience a massive disparity in their quality of life when moving between mom's house and dad's house. Imagine if Robert lives in a luxury high-rise, while the children stay with Jennifer in a cramped apartment. This disparity creates psychological friction for the children and fuel for future litigation. The mediation philosophy seeks to balance the two households. We might look at the total household spend and allocate resources to ensure both homes have high-speed internet, reliable transportation, and the ability to maintain the children's extracurricular activities. This is the family-centric economic model. It requires a level of transparency that is rarely achieved in litigation. Robert has to show his true bonus structure, and Jennifer has to be honest about her projected earning capacity. This brings us to the rise of the virtual divorce and the use of AI-driven financial modeling. In 2026, many couples are opting for fully remote mediation. This isn't just a matter of convenience. It is a strategic choice. For high-conflict couples, the physical presence of the other person can trigger a neurological response known as amygdala hijack, where the emotional center of the brain takes over and shuts down the logical prefrontal cortex. By mediating via high-definition video conferencing, we create a digital buffer. Mediators in 2026 are also utilizing neutral financial software that can run thousands of simulations in seconds. If we change the child support amount by $200, how does that affect Jennifer's ability to qualify for a mortgage in 3 years? If Robert front-loads the spousal support, what are the potential tax implications under the current federal guidelines? In the past, these questions would take weeks for accountants to answer. Now, the data is projected onto a shared screen in real time. This immediate feedback loop prevents the escalation of conflict born from uncertainty. But as the math becomes clearer, the human element can become more volatile. We have to talk about the tactic of income imputation. This occurs when one parent, usually the one expected to pay support, suddenly decides to quit their job or take a lower-paying position to artificially reduce their income. In a courtroom, this leads to a trial where vocational experts testify about what that person could be earning. In mediation, the philosophy is one of objective standards. The mediator might cite historical trends in the local labor market and suggest that support be based on Robert's 5-year average earnings, rather than his current, artificially low month. This holds the party accountable without the need for a hostile cross-examination. Step by step, we also address the contingency planning philosophy. Life in 2026 is unpredictable. What happens if Robert's company goes under? What happens if Jennifer's health prevents her from finishing her degree? A mediated agreement often includes modification triggers. Instead of having to sue each other every time life changes, the agreement specifies that if income fluctuates by more than 15%, the parties will return to the mediation table for a 3-hour tune-up session. This keeps the power in the hands of the parents rather than the state. As we conclude this deep dive into the financial heart of the process, we see that the philosophy of mediation is moving toward a more holistic view of the American family. It recognizes that wealth is not just cash in a bank. It is the stability of the children, the career trajectory of both parents, and the preservation of the peace. We have moved from the battle of "I want mine" to the strategic question of, how do we both survive this? But there is an even more complex layer we haven't touched. Beyond the money and the houses lies the most sensitive asset of all, the digital legacy. In 2026, a couple's digital footprint, from shared social media accounts and family photo clouds to cryptocurrency keys and smart home ecosystems, represents a massive entanglement. Who gets the rights to the family's YouTube channel revenue? Who owns the data in the smart home hub? And how do you mediate a split when the assets are decentralized and potentially untraceable? We are entering the realm of the tech-infused divorce. In the next part, we will explore the cyber mediation protocols and the philosophy of data privacy during a split. We will reveal how modern mediators are handling the division of non-traditional assets that didn't even exist a decade ago. We will also look at the social media clauses that are becoming standard in American divorce decrees, preventing the post-divorce revenge post before it even happens. The complexity of the 21st century split is about to be laid bare. The 21st century divorce has moved beyond the physical realm and deep into the digital infrastructure of our daily lives. In the year 2026, the philosophy of mediation must account for a reality where a couple's most valuable and contentious assets may exist entirely as code, data, or online influence. This is the era of the tech-infused divorce, and it requires a mediator who is as much a digital forensic strategist as they are a conflict resolution specialist. We begin this 6th chapter of our masterclass by looking at the digital estate. In the United States, historical trends suggest that the average person now has over 100 digital accounts, ranging from financial institutions to cloud storage and smart home ecosystems. When a marriage dissolves, these connections become a tangled web of potential privacy breaches and asset concealment. Imagine a case study involving a couple named Alex and Taylor, living in a high-tech hub like Seattle. Throughout their 10-year marriage, they built a lifestyle integrated by a central smart home server that controls everything from security cameras to climate control and grocery ordering. In a traditional litigated setting, the fight over who gets the house usually overlooks the digital keys to that house. In mediation, we apply the philosophy of digital decoupling. This is a step-by-step protocol where the mediator facilitates a transition plan for every shared digital touchpoint. Who retains the primary administrative rights to the family's cloud storage where 10,000 photos of their children are stored? How do we ensure that once Alex moves out, they no longer have access to the security camera feeds in Taylor's new residence? In 2026, the potential outcomes of failing to address these issues are severe. We are seeing a rise in what is colloquially known as tech-enabled stalking within domestic disputes. Therefore, the mediation philosophy has evolved to include a digital security audit. The mediator encourages both parties to work with a neutral IT consultant to reset passwords, migrate shared data to individual accounts, and revoke third-party permissions. This isn't just about security. It is about the psychological closure of the split. By physically and digitally separating their lives, the parties reduce the number of triggers that can lead to post-divorce conflict. Now, let's go deeper into the division of non-traditional financial assets, specifically cryptocurrency and decentralized finance, or DeFi. In the American legal system, these assets are treated as property, but their volatility and anonymity make them a nightmare for litigation. Imagine Alex has been a long-time investor in various digital tokens, while Taylor has focused on their traditional joint savings. In 2026, the value of Alex's digital wallet might fluctuate by 20% in a single week. The mediation philosophy here is one of real-time valuation and distribution. Instead of fighting over what the Bitcoin was worth on the day they separated, which could be vastly different from its value on the day they signed the agreement, the mediator may suggest a percentage-based distribution. For example, rather than Alex paying Taylor $50,000 to buy out her interest in his digital assets, they might agree to a direct transfer of 50% of the tokens from his cold storage wallet to her new, individual wallet. This shifts the risk of market volatility equally onto both parties. It also avoids the complex tax calculations associated with liquidating crypto into US dollars during the settlement. Beyond the numbers, we must address the philosophy of the social media clause. In the current American landscape, a single disparaging post can have catastrophic effects on a former spouse's career, social standing, or mental health. By 2026, the social media non-disparagement agreement has become a standard pillar of the mediated settlement. This is not about censorship, it is about protecting the brand of the family. The logic is simple. If Taylor is a freelance consultant and Alex posts a series of vengeful rants on a public platform, Taylor's earning capacity could drop, which in turn affects Alex's ability to receive child support or his liability for spousal maintenance. The mediator helps the couple realize that their financial fates remain linked long after the legal paperwork is signed. The clause often specifies that neither party will post images of the children without the other's consent, and that they will refrain from discussing the details of the divorce on any social media platform. The philosophy here is the preservation of future peace through the regulation of digital noise. We also see the emergence of the digital legacy for children. In 2026, children often have their own digital footprints, from gaming accounts to educational portfolios. Mediation now includes discussions on who manages these accounts. If a child is a high-earning influencer, a scenario becoming more common in the US, how is that income managed? The philosophy of the co-parenting business model applies here. The parents must agree on a neutral third party, perhaps a professional trustee, to manage the child's digital earnings until they reach adulthood. This prevents the child's career from becoming a leverage point in the parents' negotiation. Another critical area is data privacy and the right to be forgotten within the family unit. During a marriage, people share intimate details, passwords, and medical information. The mediation process in 2026 emphasizes a clean break protocol regarding personal data. This involves an agreement that neither party will use information gained during the marriage to gain a competitive advantage in the future. For example, if Alex knows Taylor's private medical history or a sensitive professional secret, the mediated agreement includes a confidentiality provision with specific liquidated damages for any breach. This provides a layer of legal protection that is much harder to secure in a standard courtroom judgment. Step by step, the mediator also guides the couple through the division of loyalty assets. These are the frequent flyer miles, credit card points, and subscription services that define modern American consumption. While they may seem trivial in 2026, 1 million airline miles can be worth thousands of dollars in travel. The philosophy is one of equitable allocation. We don't just split the miles 50-50, we look at who is more likely to use them. Perhaps Alex takes the airline miles because their job requires travel, while Taylor takes the equivalent value in a different asset. This is the art of the trade-off that makes mediation so much more efficient than a court order. As we look at these tech-infused complexities, we see that the philosophy of mediation is becoming increasingly proactive. We are no longer just cleaning up the mess of the past. We are building the digital firewall for the future. We are ensuring that two people can walk away from each other without leaving a digital trail that allows them to continue hurting one another. This is the ultimate goal of the modern American split, a total and clean separation of physical, financial, and digital lives. But even as we master the digital realm, there is one area that remains stubbornly human and incredibly difficult to mediate: the role of extended family and new partners. In 2026, the blended family is the American norm. Yet the introduction of a new boyfriend or girlfriend remains the most common reason for a mediated agreement to fail at the last minute. How do you mediate the new partner clause without overstepping into personal liberty? How do you handle grandparents who want to sue for visitation rights in the middle of your mediation? We are about to dive into the social and emotional minefield that exists just outside the nuclear family. In the next part, we will explore the third-party influence on mediation and how to keep your mother-in-law out of your divorce settlement. The walls are closing in on the negotiation room. The negotiation room is rarely occupied by only two people, even if only two are physically present. In the year 2026, the philosophy of American mediation must confront the shadow gallery of third-party influencers, the parents, siblings, new romantic partners, and even high-conflict social circles that whisper in the ears of the divorcing couple. This is the phenomenon of the invisible negotiator. When a mediation that was progressing smoothly suddenly hits a brick wall on a Tuesday morning, it is often because one party went to Sunday dinner with their family and was told they were being taken advantage of. To master the philosophy of mediation, we must understand how to insulate the process from these external pressures while acknowledging the reality of the American extended family. Consider a case study involving a couple named Marcus and Olivia in Charlotte, North Carolina. They have reached a tentative agreement on their assets, but Olivia's mother, who provided a significant portion of their initial down payment years ago, is insisting that Olivia fight for a larger share of the home equity as a matter of principle. Olivia feels a sense of loyalty to her mother, creating an internal conflict that threatens to derail the mediation. In a traditional legal battle, this would lead to a third-party intervention or a deposition of the mother-in-law, further poisoning the family well. In the mediation philosophy, we address this through a technique called stakeholder mapping. The mediator works with Olivia to identify which of her interests are truly hers and which belong to her mother. By separating these two, the mediator helps Olivia realize that her primary interest is a peaceful co-parenting relationship with Marcus, which her mother's aggressive stance is currently jeopardizing. The mediator might even suggest a supportive third-party session. While it is rare, a sophisticated mediator in 2026 might bring the influential family member into a brief, controlled caucus. The goal is not to negotiate with the mother-in-law, but to allow her to feel heard and to explain the legal and financial reality of the mediation path. Once the third party understands that a courtroom battle could potentially drain the very equity they are worried about through massive legal fees, their stance often shifts from agitation to cautious support. Step by step, we must also address the most volatile third party, the new romantic partner. In the United States, historical trends show that the introduction of a new partner during the divorce process increases the likelihood of litigation by over 40%. The philosophy of the new partner clause is one of the most debated topics in 2026 family law. Imagine Marcus has started dating someone new and wants to introduce them to the children. Olivia is biologically and emotionally predisposed to protect her children from a stranger. If this is not handled in mediation, it becomes a flashpoint for high-conflict behavior. The mediator facilitates the creation of a social introduction protocol. This isn't about controlling who Marcus dates. It is about managing the transition for the children. A common mediated solution involves a moratorium period, agreeing that neither parent will introduce a new partner to the children until the relationship has lasted at least 6 months, or until the divorce is finalized. They might also agree that the other parent gets a brief, civil introduction to the new partner before the children do. This restores a sense of agency to the parent who feels replaced and ensures that the children are not used as pawns in a jealousy-driven power struggle. Beyond family and partners, we have the influence of the professional echo chamber. In 2026, everyone has access to legal influencers on social media and AI-driven legal bots that provide generic, often aggressive advice. Michael or Sarah might enter a session saying, "I saw a video that says I should never settle for less than 60%. The mediator must apply the philosophy of contextual accuracy. They provide the couple with localized data, actual historical outcomes from their specific county and their specific judicial circuit. By replacing the generic noise of the internet with the specific reality of their jurisdiction, the mediator grounds the conversation in facts rather than viral trends." This brings us to the complex role of grandparents' rights in the American split. In many states, grandparents have a limited legal standing to seek visitation, but the threshold is incredibly high. However, in mediation, we don't focus on the legal threshold. We focus on the child support network. The mediator helps the parents see that grandparents are a free resource for childcare, emotional stability, and cultural heritage. Instead of litigating a visitation schedule for grandparents, a mediated parenting plan might include a clause that encourages and facilitates regular contact with both sets of extended family, provided it does not interfere with the primary parent's time. This proactive inclusion prevents the grandparents from feeling the need to fund a legal battle to see their grandchildren. Let's look at the data regarding third-party funding of divorce. In the US, it is increasingly common for one party's legal fees to be paid for by their parents. This creates a massive power imbalance. If Olivia's parents have unlimited funds to fight Marcus, Marcus might feel forced to settle for an unfair deal just to avoid bankruptcy. The mediation philosophy counters this through the concept of leveling the playing field. The mediator may suggest that a portion of the marital assets be set aside in an escrow account specifically to pay for neutral experts, like a business valuator or a child specialist, ensuring that the outcome is based on professional data rather than who has the wealthier parents. As we navigate these social entanglements, we must also consider the workplace as a third-party influencer. In 2026, the stress of a litigated divorce is a leading cause of decreased productivity and job loss. A mediated divorce, by contrast, is often viewed through the philosophy of professional stability. The mediator helps the couple schedule sessions around their work commitments and discusses how to communicate the transition to their respective employers. This ensures that the very income they are fighting over remains intact. By the end of this stage, the couple has built a perimeter of privacy around their negotiation. They have learned how to say to their well-meaning friends and family, "We appreciate your support, but we are working this out in a way that is best for our specific future." This boundary setting is perhaps the most valuable life skill that mediation provides. It transitions the couple from a state of being influenced by others to a state of collaborative leadership over their own lives. But even with the external world locked out, there is one final internal hurdle. We have talked about assets, children, and parents. Now we must talk about the intangible. What happens when the mediation is almost finished, but one party refuses to sign because they aren't ready to let go of the marriage itself? This is the philosophy of the emotional divorce versus the legal divorce. In the next part, we will explore the closure ceremonies and the psychological bargaining stage that can trap a couple in mediation for months. We will reveal the specific linguistic triggers mediators use to move a spouse from the past to the future. The deep dive is reaching its psychological peak. The legal divorce is a signature on a piece of paper, but the emotional divorce is a tectonic shift in identity that can take years to complete. In the year 2026, the philosophy of American mediation has finally integrated the understanding that these two timelines rarely align. This is the stage where we encounter the phenomenon of the anchor in the past. For many couples, the mediation process slows down not because of a disagreement over a 401k or a summer vacation schedule, but because one spouse is using the negotiation as a way to maintain a connection, any connection, to the other person. Conflict in this psychological framework is a form of intimacy. If they reach an agreement, the connection is severed, and they must face the void of a new solo identity. To navigate this, professional mediators use a high-level linguistic strategy known as future-oriented reframing. This is not about being overly optimistic. It is about shifting the neural pathways of the brain from the limbic system, which manages memory and threat, to the prefrontal cortex, which manages planning. Consider a case study involving a character named Sophia in Chicago. She and her husband, David, have spent 3 sessions arguing over the ownership of a vintage record collection. The collection is worth roughly $5,000, but they have already spent $4,000 in mediation time debating it. The mediator recognizes that for Sophia, the records represent the summers they spent together in the early 2010s. The mediator uses a specific linguistic trigger. "Sophia, as you begin to design the layout of your new apartment in the West Loop, how do you see yourself spending your Friday evenings?" This question bypasses the records entirely and forces Sophia to visualize a future where she is the architect of her own environment. By anchoring the records to the past and the apartment to the future, the mediator creates a cognitive dissonance that Sophia must resolve. Historical trends in behavioral psychology suggest that once a person begins to mentally furnish their future life, their grip on the artifacts of the past begins to loosen. Another critical tool in the 2026 mediation toolkit is the closure ceremony. This is a non-legal, symbolic act that marks the end of the negotiation. It might be as simple as a shared statement acknowledging the years they spent together, or an agreement on how they will break the news to their social circle. The philosophy here is that the human psyche requires a ritual to process transition. Without it, the parties often experience a sense of unfinished business that leads to post-divorce harassment or litigation. Step by step, the mediator also addresses the bargaining stage of grief. This often manifests as conditional agreement. David might say, "I will agree to the house buyout, but only if Sophia agrees to attend family therapy with me for the next 6 months." In the legal world, this is a non-starter. A judge cannot order someone into therapy as a condition of a property split. In the mediation philosophy, however, we look at the interest behind the bargain. David isn't trying to control Sophia. He is terrified of losing his co-parenting partner. The mediator refines this into a transition plan that includes a monthly co-parenting check-in for the first year. This satisfies David's need for connection, while respecting Sophia's need for autonomy. In 2026, we are also seeing a massive rise in the use of the divorce coach within the mediation room. Unlike a therapist who looks backward at the roots of the marital failure, a divorce coach is a tactical partner who looks forward. They help the client manage the logistics of the split, finding a new school, updating a resume, or managing the social anxiety of being the divorced friend. The philosophy is one of task-based healing. By giving the client a series of small, achievable wins, the coach helps them build the confidence necessary to sign the final agreement. Let's look at the data regarding the sunk cost fallacy in American divorce. Many people stay in the litigation track because they have already spent $20,000 and they feel they need a win to justify the expense. Mediation breaks this cycle by introducing the philosophy of the clean slate. The mediator helps the couple calculate the cost of the next 6 months of war versus the cost of a compromise today. In 2026, with the high cost of living and housing in major U.S. cities, the financial peace dividend of settling early is often enough to buy a modest car or fund a year of college tuition. When the math is laid bare, the ego often yields to the wallet. However, we must also explore the dark side of the emotional divorce, the high-conflict narcissistic loop. In these cases, one party is not grieving, they are seeking to punish. The philosophy of mediation changes entirely here. We move from empathetic listening to parallel play. The mediator uses the caucus method almost exclusively to prevent the high-conflict party from gaining an emotional reaction from their spouse. They use BIF communication: brief, informative, friendly, and firm. This starves the conflict of its fuel. By 2026, mediators are even using AI-assisted communication filters that flag aggressive or manipulative language in emails before the other spouse sees them. This buffer technology is a game-changer for maintaining the peace. As Sophia and David reach the final hour of their 8th session, the mood in the room changes. It is a mixture of exhaustion and relief. They have moved through the denial, the anger, and the bargaining. They are now entering the stage of acceptance. But acceptance is a fragile state. The night before the signing, Sophia experiences a massive spike in anxiety. This is the separation distress that occurs when the reality of being alone finally hits. To manage this, the mediator provides a post-mediation roadmap. This is a document that outlines the first 30 days after the divorce is finalized. It includes everything from the date the bank accounts are officially separated to the date the kids have their first sleepover at the new apartment. The philosophy is that anxiety thrives in the unknown, and a detailed plan is the ultimate sedative. By providing a step-by-step guide to their new lives, the mediator ensures that the agreement doesn't just end the marriage, but starts the next chapter with a sense of order. But even with the emotional work complete and the roadmap in hand, a massive legal and financial trap remains. In the United States, the signing of the agreement is not the same as the execution of the assets. There is a complex, often misunderstood process called the QDRO, the Qualified Domestic Relations Order, that manages the actual transfer of retirement funds. If this is handled incorrectly, it can trigger massive IRS penalties and wipe out a decade of savings. How do you ensure that your hard-won settlement doesn't get devoured by the taxman? What are the secret wealth preservation tactics that the top 5% use during the asset transfer phase? And what happens if, after all this work, one party simply refuses to move out of the house on the agreed-upon date? We are entering the execution phase, where the philosophy of mediation meets the cold, hard steel of enforcement. In the next part, we will dive into the post-judgment minefield and show you how to protect your peace when the mediator leaves the room. The finish line is in sight, but the ground is getting dangerous. The philosophy of mediation does not end when the ink dries on the settlement agreement. It merely enters the most critical phase of its life cycle, the execution and wealth preservation phase. In the American legal system of 2026, many individuals mistakenly believe that the signing of the judgment is the finish line. However, the data suggests that a significant percentage of post-divorce conflict arises during the actual implementation of the agreed-upon terms. This is the post-judgment minefield. To navigate this successfully, we must apply a philosophy of administrative precision. This involves a step-by-step transition of assets that bypasses the friction of the tax system and the potential for one party to experience last-minute resistance. Consider the case study of James and Sarah in the high-cost-of-living area of Northern Virginia. They successfully mediated a complex estate that included a primary residence, 2 separate retirement accounts, and a shared brokerage portfolio. Their agreement was balanced, but they now faced the challenge of the QDRO. or qualified domestic relations order. In the United States, you cannot simply write a check from your 401k to your former spouse without triggering an immediate 10% early withdrawal penalty and a massive income tax liability. The philosophy of the QDRO is to create a legal conduit that allows for the tax-free transfer of retirement wealth. Step by step, the mediation process in 2026 incorporates a neutral QDRO specialist. Instead of James's lawyer and Sarah's lawyer fighting over the language of the order, the specialist drafts a single document that meets the specific requirements of the plan administrator. This is crucial because historical trends show that plan administrators for major U.S. corporations reject nearly 30% of first-draft QDROs due to technical language errors. For James and Sarah, the philosophy of using a neutral expert ensures that the transfer of $400,000 in retirement equity happens seamlessly, preserving the full value of the asset for both parties' future retirement. Next, we must address the philosophy of real estate de-escalated. In 2026, interest rates have stabilized but remain significantly higher than the historic lows of the early 2020s. This creates a massive obstacle for the spouse who wants to keep the house. Imagine a character named Robert in San Diego. His mediated agreement says he has 90 days to refinance the family home into his own name to remove his ex-wife, Elena, from the mortgage. If Robert cannot qualify for the refinance due to the 2026 credit standards, the agreement could collapse. The mediation philosophy anticipates this by building in an assumption of mortgage clause or a deferred sale agreement. Instead of a hard deadline that forces a fire sale, the mediator helps Robert and Elena agree to a tiered timeline. If Robert cannot refinance within 90 days, he must list the house for sale, but he retains the right to buy out Elena's interest at a predetermined appraisal value if rates drop within an additional 6 months. This is the philosophy of the financial safety net. It protects Elena's credit score while giving Robert a realistic path to maintaining the family home for their children. We also need to examine the execution of personal property. In a courtroom, a judge might literally tell a couple to go to their garage and alternate picking items. This is a recipe for a physical confrontation. In the 2026 mediation model, we use the virtual inventory philosophy. James and Sarah use a shared digital spreadsheet to categorize every item of value. They apply the 5-pile method: items for James, items for Sarah, items to be sold, items to be donated, and the conflict pile. By isolating the conflict pile, the items both people want, they can then apply a value equalization strategy. If James wants the vintage motorcycle and Sarah wants the heirloom dining set, the mediator helps them find a financial offset elsewhere in the agreement. This removes the emotional charge from the physical objects. However, the most dangerous part of the minefield is the emotional retraction. This occurs when the reality of moving out becomes physical. Imagine the day the moving trucks arrive. This is often when the high-conflict personality attempts to sabotage the process by forgetting to leave the keys or taking items that were specifically allocated to the other party. The mediated philosophy for this stage is the escrow of cooperation. In high-stakes cases, a portion of the liquid assets is held in a neutral attorney's escrow account until both parties have signed a certificate of compliance. This certificate confirms that the house was left in the agreed-upon condition, all passwords were handed over, and all physical property was transferred. This financial incentive ensures that the transition remains professional rather than personal. Historical trends in 2026 show a rise in post-decree mediation as a standard service. Because life is dynamic, the philosophy of the living agreement is taking hold. If James loses his job 6 months after the divorce is finalized, the agreement includes a mandatory mediation clause before any court filing can be made. This prevents a temporary financial setback from turning into a permanent legal war. It treats the divorce decree not as a static cage, but as a flexible framework for an evolving family structure. Furthermore, we must consider the case study of digital security during the asset execution. In 2026, the transfer of a shared Amazon or Netflix account might seem small, but the data history within those accounts, credit card numbers, viewing habits, and purchase history, is a privacy nightmare. The philosophy of digital sanitization requires each party to provide a digital release, confirming they have wiped their data from shared devices and changed their recovery email addresses. This prevents the digital ghosting effect where an ex-spouse accidentally receives a notification about a former partner's new location or purchases, which can lead to unnecessary emotional triggers. Step by step, the 2026 masterclass also focuses on the retitling of assets. This includes cars, boats, and small business interests. In many U.S. states, the DMV and the Secretary of State require specific forms that go beyond the standard divorce decree. The mediator provides a closing checklist that acts as a logistical map for the first 90 days post-judgment. This checklist includes updating beneficiaries on life insurance policies and pay-on-death bank accounts. Failing to do this is one of the most common ways that wealth is accidentally transferred to an ex-spouse years after a divorce. As James and Robert and the other characters in our 2026 narrative move through this final logistical gauntlet, they realize that the philosophy of mediation has given them something litigation never could: a sense of agency over their own ending. They are not victims of a court order. They are the executives of their own reorganization. But as they step out into their new lives, a final question remains. Was it worth it? When we look at the long-term data of the mediation generation versus the litigation generation, the results are staggering. The wealth gap between those who fight and those who collaborate is widening, and the psychological impact on the next generation of American children is becoming clear. In the final part of this documentary, we are going to look at the legacy of the split. We will reveal the long-term outcomes of these cases 10 years down the line and answer the ultimate question: can a divorce actually be the foundation for a more successful second half of life? We are going to look at the mastery of the new normal, and the final piece of the philosophical puzzle that determines whether you move on or stay stuck in the cycle forever. The conclusion to this masterclass is the most important part of the journey. The mastery of the new normal is not an accidental state of being. It is the intentional outcome of a philosophy that views the end of a marriage as a structural pivot, rather than a total collapse. As we conclude this 10-part deep dive in the year 2026, we must examine the longitudinal data of the American family. When we look at the legacy of the split, we are looking at how these decisions echo across the next decade of life. The philosophy of mediation concludes with the concept of generational preservation. This is the idea that the way a couple divorces creates the blueprint for how their children will handle conflict, how they will manage their own future finances, and how they will view the concept of partnership. Imagine a case study following a character named Ethan, who is now 22 years old in 2026. His parents mediated their divorce 10 years ago. Because his parents utilized the collaborative business model we have explored, Ethan grew up in a reality where his father attended his high school graduation and sat next to his mother without a security detail or a palpable sense of tension. The financial philosophy of his parents' mediation included a dedicated college savings plan that was protected from the whims of a judge or the depletion of legal fees. Consequently, Ethan graduated debt-free. Historical trends in developmental psychology suggest that children of mediated divorces exhibit lower rates of stress-related academic decline and higher rates of relationship stability in their own adult lives compared to those from high-conflict litigated backgrounds. This brings us to the mastery of the financial phoenix. In the United States, the traditional narrative is that divorce is a financial death sentence, particularly for women or the lower-earning spouse. However, the data from 2026 indicates a different potential outcome for those who choose mediation. By avoiding the $50,000 to $150,000 loss in marital equity typically consumed by a 2-year legal battle, mediated individuals start their single lives with a significantly higher capital base. Let us look at a character named Maria in Phoenix, Arizona. After her mediated divorce, she retained her share of the home equity and a portion of the liquid brokerage accounts. Because she didn't spend those assets on a trial, she was able to pivot that capital into a small business venture in the burgeoning 2026 green tech sector. Step by step, the mediation philosophy provided Maria with the emotional and financial bandwidth to innovate. In a litigated scenario, Maria would likely have spent those 2 years in a state of chronic cortisol elevation, focused on defense and survival. In mediation, she was focused on the terms of her reorganization. This is the mastery of the transition. When you are the architect of your own settlement, you possess a deep, intimate understanding of your financial levers. You know exactly what your overhead is, you know the tax implications of your assets, and you have a roadmap for your next 5 years. This level of financial literacy is a byproduct of the mediation process itself, which acts as a crash course in personal wealth management. Furthermore, we must address the philosophy of the blended legacy. In 2026, the American family is often a tapestry of biological children, stepchildren, and multiple sets of former in-laws. The mastery of this complex social structure requires the continued application of the mediation mindset. Those who have mastered the philosophy of interests over positions find it easier to navigate the introduction of new spouses, and the arrival of new children into the extended family network. They treat these changes as new data points to be integrated into the existing family business model, rather than threats to their personal territory. Consider the scenario where Ethan's father remarries in late 2026. Because the original mediated agreement included a new partner protocol and a co-parenting communication guide, the integration of a stepmother is handled with transparency and respect. There are no surprise introductions and no weaponization of the children. The legacy of the mediation is a culture of high-functioning communication that persists long after the legal case is closed. This is the ultimate value add of the process. It doesn't just solve the problem of the divorce, it upgrades the operating system of the entire family. As we reach the final minutes of this masterclass, we must look at the mastery of the self. The most profound legacy of mediation is the preservation of one's own character. In the adversarial system, people are often encouraged to be the worst versions of themselves. They are coached to highlight their spouse's flaws, to exaggerate their own needs, and to hide their assets. This behavior leaves a psychological stain that is difficult to wash off. In mediation, you are encouraged to be a problem solver. You are asked to be fair, to be transparent, and to be a visionary for your children's future. The character name we started with, Michael from Austin, is now 3 years post-divorce. He looks back on the process not with the trauma of a survivor, but with the quiet pride of a leader. He didn't win a war. He managed a crisis. He preserved his relationship with his children, he protected his retirement, and he maintained his professional reputation. This is the mastery of the new normal. It is the realization that while the marriage ended, the life did not. Historical trends show that the mediation generation of 2026 is becoming the leading voice in a new American era of civil dispute resolution. This philosophy is now bleeding into other areas of life, from employment law to neighborhood disputes and international diplomacy. We are learning as a society that the most sustainable solutions are the ones we build ourselves. The divorce industrial complex is a relic of a litigious past. The future belongs to those who can sit at a table, look at a spreadsheet, and find the common ground in the middle of a storm. As you close this chapter of your journey through the philosophy of divorce mediation, remember that the data is clear. The potential outcomes of a collaborative approach far outweigh the scorched earth tactics of the past. You have the tools to understand the shadow of the law, the tactics of interest-based negotiation, and the psychological frameworks of emotional divorce. You are now equipped with the blueprint for a civilized exit. But the world of American law and finance never stops moving. As we look toward 2027 and beyond, new challenges are appearing on the horizon. From the impact of universal basic income trials on child support formulas to the emergence of neuro-legal technologies that can detect deception in the mediation room, the landscape of the American family is about to undergo another seismic shift. The evolution of the split is far from over. In our next documentary series, we will explore the post-family economy and the radical new ways Americans are defining home in a decentralized world. The deep dive continues as we look toward the next frontier of the human contract. Stay tuned for the exploration of the 2030 family unit and the technology of love and law.